This video contains excerpts from an online workshop that the USALI Law Institute held in June 2020. The workshop participants were legal professionals or scholars from mainland China, Taiwan, and Japan, who were already broadly familiar with the United States criminal procedure and evidence rules. The presenters were experienced judges, defense counsel, former prosecutors, and law professors. The workshops were designed and led by USALI Law Institute Senior Research Scholar Ira Belkin, a former federal prosecutor.
Principle to understand on the scope of cross-examination is the judge really is in charge, and frankly the rules have some ambiguity to them, and it's up to the judge to assure that the cross-examination is proper, is not for some purpose of embarrassment or some irrelevant purpose. And that power of the judge is embodied right in this rule that we're looking at in this slide. And this is Federal Rule of Evidence 611, which lays out the mode and order of examining witnesses and presenting evidence. And this is the rule that specifically gives the court, which means the judge, the authority, the ability to control all examination of witnesses in court. And this is the source of the judge's power to sustain objections to questions that the judge believes are irrelevant or designed to harass or to embarrass the witness or for any improper purpose. That's the way the witness is protected, is by the judge's ability to curtail the scope of cross-examination. So there are several rules that you see on this slide governing the scope and the type of questioning that can be used in cross-examination. We start with the scope of cross-examination, and according to the rule, cross-examination should not go beyond the subject matter of the direct examination and questions about the witness's credibility. So we start with that sort of basic principle that on cross-examination, you're allowed to ask about any subject that was asked about on direct examination, and you're allowed to test the credibility of the witness. Now, sometimes cross-examination goes beyond those areas, and then it's all up to the judge to decide, and that's the last portion of that provision there. The court may allow inquiry into additional matters as if on direct examination. In other words, if the lawyer cross-examining the witnesses wants to go beyond the subject matter of what was inquired of on direct examination, the judge can allow it. It saves a lot of time, and usually the judge does allow it. The alternative to not allowing a lawyer to go beyond the scope of the direct would be that lawyer would have to recall the witness later on in the trial when that witness's client is presenting its case to the jury. So in a criminal case, of course, the government goes first. It has the burden of proof. And the cross-examination is conducted in the context of the government's presenting of its case. Typically, if a defense lawyer wants to go into new areas on cross-examination, even though it's the government's case, the judge will typically allow it because it's a time saver, and it avoids the problem of the defense having to recall the witness back to the stand in the defense portion of the case. So there is quite a bit of flexibility there. As far as the types of questions that are permitted, this is the fundamental difference between direct examination and cross-examination, is the use of leading questions. In direct examination, you are generally speaking not permitted to use leading questions. The idea is that since you're calling the witness the witness should be required to tell the story in his or her own words. So the lawyer's questions should be open-ended, and the lawyer shouldn't be putting words in the witness's mouth when it's the lawyer who called the witness and assuming it's a friendly witness to that side. The contrary situation is on cross-examination. Typically, in cross-examination, it's a more hostile or adversarial relationship between the lawyer who's questioning and the witness. And so in that scenario, the rules loosen and the lawyer is allowed to use leading questions. In fact, leading questions are really the fundamental base of cross-examination is the use of leading questions. You don't always use leading questions, but most of the time you do. And that is your way of confronting the witness and trying to get the witness to acknowledge or admit facts that the witness may not be inclined to admit. And one of the tools that the lawyer has is the use of leading questions, questions which do suggest the answer and ask for more of a yes or no. Leading questions are generally not permitted on direct. It does say there's an exception there, except as necessary to develop the witness's testimony. That's things like background. You can ask some leading questions just to kind of get the ball rolling on your direct examination. But on cross-examination, as it says here, you are allowed to ask leading questions. And also, and this is another kind of an exception to the rule, if a lawyer calls a party who is hostile to his position, then this rule about open-ended questions goes away and the lawyer is allowed to lead the witness. And again, this is all based on the concept that if the witness is friendly to the lawyer on the friendly side of the case, they should have to tell the story in their own words and the lawyer shouldn't be able to put the words in the witness's mouth. But if the witness is more hostile or in some way not as aligned with the lawyer, then the lawyer is permitted to ask leading questions.
Remember, both the prosecution and the defense have the right to cross-examine whatever witness comes to court. So objections are used by both sides in a case. And objections can be made during direct testimony, during cross-examination, at any point during the witness's testimony. There are objections filed or stated in court by the lawyers. And really what the objection is designed to do is to ask the judge to control the line of questioning, to rule on whether or not the way the question was asked was proper. So the first item on the slide is relevance, and that just means, is this question an appropriate subject and relates to the issue that's out on trial or the subject of the proceedings? What that is, what's relevant in a particular case, you'd think it would be obvious, but can be the subject of enormous dispute. On the defense side, we're often claiming that the government is trying to put in other things to make the client look bad, but that actually have nothing to do with the charges against him or her. So it's very important on the defense side that the evidence the prosecution presents is limited to the issue that's the subject of the charges. Asked and answered simply means you can't keep repeating the same question. You can't keep coming back to the same question you've already asked to get it repeated many times, maybe in an effort to sway the jury or badger the witness into answering it differently. Hearsay, we've talked a lot about already, but obviously there could be questions designed in, even if it's in an underhanded or slightly roundabout way, designed by the questioner to have the witness talk about, for example, a conversation they had with someone. What did he tell you that day? That type of question would be objectionable unless there was some exception to the hearsay rule. The fourth category assumes a fact not in evidence. Sometimes the premise of a question or there could be an assumption in a question that assumes something that's actually in dispute and there's been no testimony about it. So you can't ask a question that has as its premise an issue that's in dispute and has not been presented in court yet. On the fifth category, objection as to compound, I think it's best demonstrated with an example. For example, if someone were to ask, isn't it true that you left your house that night at 11 o'clock and you were wearing the white shoes? There are two facts in that statement. Maybe they left the house at 11 o'clock, but they weren't wearing the white shoes. So it's not susceptible to an easy answer. You can't put two different facts or two different questions into one question. Leading questions are totally appropriate and in fact are the norm. They're what's used on cross-examination. But for direct examination, those types of questions are inappropriate. And if a prosecution is most often the prosecution that is presenting witnesses and doing the direct examination, if they start trying to lead the witness and sort of put words in their mouth and control the storytelling to such an extent that it seems unfair, the defense lawyer will object that it's leading. Now, I will say judges do give a little bit of leeway, especially if the witnesses are not sophisticated witnesses. They do allow a little bit of leading questions even on direct, in my experience, especially if it's the government. Beyond the scope of direct, that goes to the question of what is the proper scope of cross-examination. So again, here's an area where judges give the defense a little bit of leeway because, as Larry said, if we want to ask questions of the witness that are slightly beyond the topic of what the government asked the witness, we technically could bring back the witness when we present the defense case, but that would be highly inefficient to have the witness be dragged back to court. So the judge will generally let a defense lawyer, as long as the questions are relevant and proper, otherwise go somewhat beyond the scope of direct in the interest of efficiency. Argumentative, I think this is where TV sometimes misleads the average viewer as to what cross-examination looks like, because the confronting a witness, even though it sounds like an aggressive mode, doesn't always mean, and certainly should never mean, that you're arguing with the witness. And in fact, I think most defense lawyers would think arguing with a witness is not effective. It's not an effective device at trial, and it's certainly judges don't like it and will shut it down pretty quickly.
As the slide says, these are the most common objections. I'm sure there are other ones as well. And you'll notice that a lot of them are designed to enforce the rules that Larry talked about, to bring the judge's attention to a question that may be bordering on misleading or deceptive because it has two questions in one, or because it assumes a fact that hasn't been proven. So objections are partly a way to enforce the rules governing both direct and cross-examination.
I have to say, in my own experience, I've never actually had a child testify in any proceeding that I have done, nor have I had a person with intellectual disabilities. So I'll answer it with just general principles, which is it's all going to be up to the discretion of the judge as to what he or she feels is fair under the circumstance. First of all, a witness has to have a certain minimum mental capacity in order to qualify as a witness. In other words, if someone had a disability or was so young that they couldn't even be trusted to be able to relay information at all, there would be some earlier determination as to whether this person could even be a witness in a case. But assuming that they pass that test, I think any judge, from my experience, would loosen the rules for children or those with an intellectual disability to make it easier for them to testify, but to try not to loosen it so far that it was really the lawyer who was testifying and not the witness. So a judge would have to weigh, balance those factors of making it easier for the witness to testify versus losing the accuracy and making sure it's really the witness's memory and not just a witness saying yes, yes, yes to whatever the lawyer suggests to him or to her.
Your approach and style and form of questioning as to each witness will vary depending on the kind of witness you're cross-examining. So obviously, if you do have a vulnerable victim, your approach to questioning that person will be very different than if it's a police officer. You can take a much more aggressive and confrontational tone and style of questioning with the police officer. And as to children or young people or vulnerable people, your strategy just has to be different.
Yeah, and just to add to that, I mean, the last thing you want jurors to think of you is that you're being mean or unfair to a vulnerable witness. That will not help you in the case. It's often said that you can't ask a question that you don't know the answer to, but I think that's an overstatement of the principle. There are often times on cross-examination where I think you can ask a question that you don't know the answer to, as long as you are comfortable that you know you can handle it no matter what the answer is. And there are situations where you can rest pretty comfortably that no matter what the answer is, you have a plan that's good for you. So it's not necessarily the case that you need to know the answer to every question. But as to your question about what does the lawyer know in advance and how do you know what you need to know, so that's a very big topic. It's a topic of a lot of debate. I think that on the criminal side in the United States, most criminal defense lawyers would take the position that they don't get to know enough about the government's case prior to trial, that the rules are too restrictive and that we don't get enough information. Interestingly, that is the opposite on the civil side of cases in the United States. But in a criminal case, typically, at least in the federal system, you do not have a right to take depositions of the witnesses, of the government's witnesses, or any other witnesses. And so you're left with a much more limited pool of information. And what you mostly get as a federal criminal defense lawyer is the interview notes that the government took when it interviewed its witnesses. That's typically what's turned over to you a few weeks before trial, is the government's interview notes of the witnesses. It's true that if the witness has given any sort of sworn testimony, you get that as well, but that's rare. Usually the witnesses have not given any prior sworn testimony. Sometimes yes, sometimes no. So the most important thing you're given is these witness statements that the government has written. And the problem with those witness statements is, number one, it's only what the government has chosen to write down. They don't have a legal obligation to write everything down. They write down what they choose, and they're allowed to write down what they choose. It's not considered improper. You get only what the government has chosen to write down in its interview notes. And that leaves you with a lot of questions unanswered, which does make the job of a defense lawyer very, very challenging. The other problem with those witness statements is they are the government's notes. They are typically not shown to the witness. They're not signed by the witness. And so the witness isn't really bound by those notes. And this comes up often on cross-examination, that the witness may stray from those notes, say something different from those notes, but It's challenging to cross-examine the witness from the notes because those are just the government's notes. They're not the witness's own words, and they haven't been approved by the witness. So there's a gap between the government's notes and what the witness can say on the witness stand. But that's the principal way that you're given information. The other information you get as a federal criminal defense lawyer is you do get any documents that the government plans to offer in the case. You have to be given that before the trial starts. If there are any tape recordings that they're going to use, you have to be given that as well. So those are the basic sources of your knowledge.
That emphasizes the fact that we feel on the defense side, we don't get enough information in the federal system, emphasizes the importance of defense counsel doing their own investigation as well, and trying to get either statements that or conduct that the witness may have engaged in that is not specific to the government's investigation, but can somehow be used by the defense lawyer to show the jury that the person is not credible, is not reliable, has conducted themselves in ways that would be offensive or upsetting to a jury, and therefore, bolster the defense claim that this person should not be relied upon. So we supplement what we get from the government with our own investigation.
Yes. And Justine, I completely agree with that, although I think what I have generally found, which I think is common, is often if you send an investigator out to talk to a prospective witness, the witness doesn't want to talk to the defense. The witness is willing to talk to the government because they're kind of afraid of the government. They're not afraid of the defense, and in fact, they're afraid of talking to the defense. So it's a challenge, I think, for the defense to get that some kind of investigative knowledge, although I totally agree with you that you have to get whatever you can.
I just want to make sure we also clarify what the rules are and then talk about, how much the rules are followed. So as Larry mentioned, he mentioned two categories of evidence the government is required to turn over. One is the prior statements of the witness, which may be not the direct statements of the witness, but maybe notes prepared by a government agent of the witness. And the other is documents or recordings and testimony. Legally, there are two other categories of evidence that the government's required to turn over. And one is called Brady material, which is any evidence that might be helpful to the defense. The other is a category of Brady material. Also, Brady is named for a Supreme Court case. It's called Giglio material, also another Supreme Court case. And that's anything that the defense might use to impeach a witness. So if a witness has criminal convictions, or if they have an agreement with the government about what might happen to them if they testify, or anything, something in their personnel records that reflects on their honesty. That's the legal principle. I think in practice, the enforcement mechanism for Brady and Giglio material is basically the honor system for prosecutors, that prosecutors have to make their own judgments about what would be helpful to the defense and what would be impeachment material. And there are some of these categories that I mentioned: prior and consistent statement, or criminal conviction, or something that clearly reflects on the credibility of the witness. But if the prosecution doesn't turn that over, it's often very difficult for the defense to even know that exists. And I think that's where there's a lot of controversy in practice.
In my experience, judges, of course, have the right to ask questions here. And some judges allow jurors to pose questions. I have seen that, although it's not common. I think it's a helpful practice. I think that certainly it's much more common. Judges do ask questions of witnesses. I wouldn't say it happens all the time, but it's not as rare as jurors asking questions, which is far more rare. I think that it's a helpful practice. I think the danger is that jurors read a lot into the judge's questions. So it's very easy for the jurors to, in their minds, think the judge is taking some position. Maybe the judge doesn't believe the witness, and that's why he or she is asking these questions. And so that's the danger, is that the jurors will read too much into it. And we do not want the judge to influence the juror's view of the evidence. So I think it has to be very delicately handled by the judge to make it as safe as possible, that the juror is not going to read too much into it. And I think that's why judges are very hesitant to ask questions, is they're worried that their questions will influence the jury in some way, and they don't want that to happen. As to the jurors asking questions, that's probably a safer practice, because the jurors don't have the same clout in the courtroom as the judge, the same power in the courtroom. But I think there's a concern about just the process of how do you do it, how do you make sure the question is appropriate, has to be carefully vetted by the judge, so it's kind of cumbersome, it's kind of time consuming. And I think that's why most judges don't allow it, is they just think it's too difficult to work out the process in some way that makes it fair and safe. But some judges do allow it.
If there's a common jury instruction given when a judge has made comments or asked questions, that the jury should not draw any inference from the judge's questions or answers, but there's always a question whether jurors can follow that instruction.